Good afternoon, everyone. This is Allison Chow. I'm here with AABA and the Solo and Small Firm Committee, and we are very pleased today to have Anna Liu and Stephanie Foster with us, presenting a webinar on understanding COVID-19's impact on California real property and housing litigation, or more specifically, the eviction moratorium that is currently in effect in California and various cities at this time. So before we begin, I'd like to let you know that this event is eligible for 1 hour of general MCLE credit. So please sign in for this event by clicking the link in the live chat or by refreshing and clicking the link at the beginning of the video description. And in the description, you'll also find the links to the written materials, which you'll see on the PowerPoints today, an evaluation form, and the event registration form if you haven't registered for this event. And at the end of the webinar, AABA will send you certificates of attendance for your records, MCLE records. So again, if you have not yet registered, please do register on AABA's website at the link in the video description. And if you'd like to see the slides from today's presentation or would like to forward the slides of the panelists, it's also available in the written materials on AABA's website. All right, so before we begin, I'd like to introduce our esteemed panelists today. They're from the firm of Stephen Adair, MacDonald Partners, professional corporation. Our first panelist is Anna Liu. She's a partner at the firm, and she primarily specializes in real estate and civil litigation. She has significant experience representing clients in a variety of real estate matters, including partitions, buyer-sell disputes, and commercial and residential landlord-tenant actions. And in addition to her practice, she's really active in the legal community. She's currently serving on the executive committee of the California Lawyers Association Real Property Law Section, and as a co-chair of the executive committee of the Bar Association of San Francisco Barristers Solo and Small Firm Section. She was elected as a Northern California Rising Star and by the Super Lawyers magazine from 2017 to 2020. And we're very, very happy to have her expertise in joining us on this panel today. With Anna is her colleague, Stephanie Foster, who's also a senior associate at the firm of Stephen Adair, MacDonald and Partners. She also specializes in real estate and civil litigation, and she represents clients in a wide variety of legal disputes, including commercial and residential landlord-tenant matters, quiet title actions, partitions, and buyer-seller disputes. And she's been instrumental in obtaining settlements for individuals, both landlords and tenants, in numerous landlord-tenant cases and real property disputes. And she has extensive litigation experience and having tried numerous cases in both San Francisco and Alameda County Superior Courts. And she also is a rising star at the Super Lawyers. And we are, again, very, very fortunate and pleased to have them and have them share their expertise with us on this really important topic. So with that, I will turn it over to Anna to begin our presentation. Thank you.
Thank you, Allison, and thank you for having Stephanie and I here today. We're happy to share what's happening on the statewide and local levels right now due to the coronavirus and all of the changes that have happened with respect to real property litigation. So I'll go ahead and get started and give our viewers a brief overview of what we'll be covering today. In response to the current global crisis, authorities at the federal, state, and local levels of government have enacted emergency measures, including eviction moratoriums and changes to court operations. So today we will examine the current state court and judicial court orders as they pertain to housing and real property. We'll also take a look at the statewide executive order on evictions, and then we'll survey what's happening on the local levels, including San Francisco and Oakland, here in the Bay Area. And lastly, we'll give some practical pointers for practitioners who may represent property owners or tenants or landlords and tenants who are trying to navigate themselves through this change. And then we'll also save some time at the end to address some questions that you may have.
Before we dive in too deeply on the statewide level, I want to take a quick second to touch base on the federal eviction moratorium. The CARES Act, Section 4024B, prohibits landlords of covered dwelling rentals from initiating eviction proceedings or charging late fees or other penalties against a tenant for non-payment of rent. The federal eviction moratorium protections extend 120 days from enactment. So it began on March 27th and will end on July 25th, 2020, unless it's extended. The CARES Act eviction protections only apply to covered dwellings, which are rental units and properties that participate in federal assistance programs, are subject to a federally backed mortgage loan, or are subject to a federally backed multifamily mortgage loan. To further explain, covered federal assistance programs include public housing, housing choice vouchers, Section 8 project-based rental assistance, rural housing programs, and the low-income housing tax credit program. Under the federal eviction moratorium, to be clear, tenants are still required to pay the rent owed after this 120-day grace period expires. Anna?
Thanks, Stephanie. So next we'll turn to the state level and survey what's happening in California across the board. So turning to a timeline of the events. First, to give you a brief overview of how we got here, California Governor Gavin Newsom signed a series of executive orders in response to the COVID-19 pandemic. So we'll focus on the housing-related executive orders. Back on March 4th, he proclaimed a state of emergency in California as a result of the threat of COVID-19. And then a couple of weeks later, on March 16th, he issued Executive Order N28-20, which basically suspends state law limitations on local jurisdictions that impose restrictions on residential or commercial evictions. So that order gave local jurisdictions the power to enact their own eviction moratoriums, which many cities across the state have now done. A couple of days later, on March 19th, he issued Executive Order N33-20, which is what we all know as shelter in place. So that forced us all to basically stay home unless we were exempted. And then on March 27th of 2020, Governor Newsom issued Executive Order N37-20, which we'll discuss today in more detail. And that executive order temporarily restricts the ability of landlords to evict residential tenants for non-payment of rent if the rent is not paid due to reasons related to COVID-19. So now let's get into Executive Order N37-20, which is state residential eviction moratorium. So first, what does Executive Order N37-20 do? Well, it's basically a 2-month halt on evictions of residential tenants who can't afford to pay their rent because of this pandemic. So it delays evictions in California and gives any tenant who is evicted, who is served with an eviction notice while this order is in place, an extra 60 days to respond to a complaint. Typically, a tenant or defendant has 5 days under Code of Civil Procedure Section 1167 to respond if an eviction is personally served. So it gives tenants a little bit more time. Also, it prohibits any sheriff or law enforcement from enforcing any eviction order against a tenant as long as the tenant meets the criteria of that order. But it's important to know that it doesn't stop new evictions from being filed, and it doesn't override any measures that cities or counties have enacted. So in order for tenants to avail themselves of this protection, they must meet certain requirements. The first is that the rent owed before March 27th must have been paid to the landlord, and then the tenant must notify the landlord in writing before the rent is due, but no later than 7 days after the rent was due, that the tenant needs to delay some or all of their rent payments due to a reason related to COVID-19. So it's a more broad order because reasons related to COVID-19 are broadly defined under this order, which I'll get into in a minute. And the third component is the tenant must also provide verifiable documentation, and we'll discuss examples of this shortly. So what are some reasons that a tenant may not be able to pay their rent under Executive Order N37-20? So one example is if the tenant is unavailable to work because they were sick with a suspected or confirmed case of COVID-19, or perhaps the tenant was caring for a household or family member who is sick with a suspected or confirmed case. Alternatively, the tenant may have been laid off or had a reduction of hours or income resulting from COVID, or the government's response to COVID-19. Alternatively, the tenant could have missed work to care for a child whose school was closed. The third component is that tenants must provide verifiable documentation under the executive order. So the statewide order actually lists out some specific examples. A lot of the local moratoriums don't provide any guidance on this. So the list we provided here is not exhaustive, but these are the items that the statewide order specifies that tenants may provide as verifiable documentation showing they can't pay their rent. So that could be a termination notice, a payroll check, pay stubs, bank statements, medical bills, or signed letters or statements from an employer or the tenant supervisor explaining their changed financial circumstances and their inability to pay. The protections are in effect through May 31st, so the end of this month. And it's really important to know that this order doesn't waive rent or forgive the rent, it just simply delays it. So the rent is still owed to the landlord. So next I'll turn to what happened at the state court level and what the state courts did in response. So back on March 16th, the California Chief Justice Tani Kantil-Sakuue issued guidance to trial courts seeking emergency orders to adjust or suspend their court operations. And then on March 18th, the Supreme Court of California expanded their mandatory e-filing of all documents, including briefs. March 20th, the Chief Justice issued a second advisory order with new guidance to the state's superior courts to try and mitigate some of the health risks to their judicial officers, court staff, and court users. And then just a few days later on March 23rd, the Chief Justice issued a statewide order granting emergency powers to all superior courts pursuant to her authority under the California Constitution. And that order continued all trial dates by 60 days and allowed courts to immediately adopt new rules to address the impact of the COVID-19 pandemic. And then on March 30th, she issued another statewide order granting additional powers to superior courts. And she also suspended jury trials for 60 days from the date of the original trial date. So then pursuant to that local order, the state order, then local courts issued their own general implementation orders. I'll now turn to what the California Judicial Council did as a response. So on April 6th, the California Judicial Council adopted 11 new emergency rules that pertain to court operations during this pandemic. But since then, 2 more rules have been added, so now there are 13 rules. 8 of the rules are related to civil matters and the remainder are for criminal matters. For purposes of our presentation today, we're just going to focus on Rule 1, which pertains to unlawful detainers. But I will add that most recently on April 17th, the Judicial Council added Emergency Rule 12, which requires attorneys to e-serve and receive notices and documents in all general civil actions, also in family and probate proceedings, if requested to do so by the other party. There are some exceptions, like for small claims or unlawful detainers. They're not subject to Rule 12. So the rules will stay in effect through 90 days after the governor declares that the state of emergency is over, or if their rules are amended or repealed by the Judicial Council. So let's get into Emergency Rule 1, which pertains to unlawful detainers. And it applies to all evictions, regardless of their cause, except for evictions that are found to be necessary for the public health or safety. And again, this rule will remain in effect until 90 days after Governor Newsom lifts the state of emergency. So first part of Rule 1 is that a court may not issue a summons on a complaint for an unlawful detainer. So that's a big deal because let's say a property owner serves a notice to a tenant for breach of the lease or nuisance or some other basis, and then the tenant doesn't comply with that notice, then the landlord exercises their legal right to file the eviction complaint in court. Well, pursuant to Emergency Rule 1, the court will not issue a summons on that complaint. So the landlord will not be able to begin litigating a UD because there won't be a summons. And again, the only exception is if the court finds that that unlawful detainer is necessary to protect public health and safety. Also, a court may not enter default or a default judgment unless for failure for the defendant to appear. So what that means is if the defendant doesn't timely respond to the complaint, then a court may not issue a default judgment. Again, the exception is if it's necessary to protect public health and safety. Also, the rule extends the time for trial. So typically in an unlawful detainer case, when either party files a request to set a case for trial, the court has to provide a trial date within 21 days of when that request is filed. But under Emergency Rule 1, the courts have now extended that to 60 days. So the court may not set a trial earlier than 60 days after the request has been set. Also, any trials set in UD proceedings as of April 6th must be continued at least 60 days from the initial trial date. And again, this rule will sunset 90 days after the governor ends the state of emergency. So next, Stephanie will talk about the local measures and what's happening around the Bay Area.
Great, thanks, Anna. I'm going to start with the city and county of San Francisco. Initially, on March 13th, 2020, San Francisco Mayor London Breed ordered a temporary 30-day suspension of a landlord's ability to evict tenants who were unable to pay rent due to financial impacts caused by COVID-19. The order was then supplemented on March 23rd, 2020 to clarify the moratorium and expand the reach of the moratorium. Currently, the San Francisco moratorium prohibits all residential evictions except evictions due to violence, threat of violence, or health and safety issues, or evictions under the State Ellis Act for 60 days after the mayor's order expires. On April 30th, this order was extended again for an additional 60 days through June 29th, 2020, or if the state of emergency ends or the mayor declares that the local emergency is over. Looking specifically at non-payment of rent evictions in San Francisco, if a tenant misses a rent payment that becomes due on or after March 13th during the local emergency, the landlord cannot evict the tenant if, first, the tenant provides notice within 30 days of the rent being due that they are unable to pay rent due to a financial impact of COVID-19. To unpack that sentence a little bit, under the mayor's order, financial impact means a substantial loss of household income due to business closure, loss of hours of work or wages, layoffs, or any extraordinary out-of-pocket medical expenses. Then a financial impact is related to COVID-19 if it was caused by the COVID-19 pandemic, the mayor's proclamation, the health officer's declaration of a local health emergency, or public health orders related to COVID-19 from local, state, federal authorities. So if the shelter in place caused your business or work to close. Then after the notice requirement, the tenant is required within 1 week of providing that notice to provide written documentation that the rent payment was missed due to a financial impact of COVID-19. The order states that this is satisfied with documentation or other objectively verifiable information that due to the financial impacts of COVID-19, the tenant is unable to pay rent. Practically, a tenant can satisfy this requirement with a letter, email, or other communication written by the tenant that explains the financial impact they are experiencing. The order does not make third-party documentation necessary to satisfy, but obviously it's advised if you can make it for your landlord. If the tenant provides the notice and documentation, then they have an additional month after the date of providing documentation to pay the rent. However, the April 30th order also allows the tenant to use the moratorium as an affirmative defense if the landlord attempts to evict them, even if they didn't satisfy the notice or documentation requirements. If a tenant then fails to pay rent after that 1 month period, the landlord has to provide the tenant written notice of the breach and discuss with them in good faith to develop a payment plan for the tenant. A landlord cannot recover possession for non-payment of rent for 6 months after the order expires. So practically, this means that the landlord cannot bring a non-payment of rent eviction through December 29th, 2020. The landlord on their own can provide additional time if they choose. However, a tenant's failure to make an agreed upon rent payment during that initial 6-month period does not alter that 6-month time period in the order. San Francisco also offers protection for commercial tenants. Qualifying commercial tenants that fail to pay their rent can't be evicted if the missed payment was due to a loss of income related to COVID-19, unless first the landlord provides a written notice to the tenant of the violation and provides the commercial tenant the opportunity of at least a month to cure or provide documentation to the landlord of their inability to pay rent due to the financial impacts of COVID-19. To be a qualifying business for the commercial eviction moratorium, you would have to be registered to do business in San Francisco, making less than $25 million in the 2019 tax year. And then commercial tenants may satisfy their documentation requirement with letters, emails, written communication to the landlord or their agent that explains the financial impact. Again, third-party documentation isn't necessary, but it's always advisable. The San Francisco commercial eviction moratorium has been extended once for a 30-day period, so it now covers all rent payments that become due through May 17th, 2020. Just to tie this all together, again, both residential and commercial tenants are not relieved of their obligation to pay rent during the local emergency or under these orders. And if a landlord proceeds with serving any notice during the emergency, they must include a new form with their notices that's available from the San Francisco Rent Board. Locally, San Francisco Superior Court has reduced operations and is only providing necessary and essential services. And this has been extended through the period of March 17th through June 1st, as they've been advised by public health officials. In San Francisco, the period of March 18th through April 15th was deemed a holiday for purposes of computing time under Code of Civil Procedure 1167, with the exception of unlawful detainer cases resulting from violence, threats of violence, or health and safety issues. And then the period from April 16th to June 1st is deemed a holiday, and the order includes this language: if the emergency condition caused by the COVID-19 pandemic substantially interferes with the public's ability to file papers in a court facility on those dates. There isn't much more explanation beyond that sentence, so it would be up to you, opposing counsel, and the court to decide if the party seeking the additional extension qualifies. In San Francisco Superior Court, the trial dates for all cases in the civil trial calendar have been vacated up to June 1st, and we will be getting new trial dates soon, hopefully. Specific to unlawful detainers in this webinar, in San Francisco, all actions in unlawful detainer cases, including trials, motions, discovery, ex parte applications, with the exception of those unlawful detainers specifically resulting from violence, threats of violence, or health and safety issues, are stayed for 90 days until June 19th, 2020. The period of April 6th through June 19th, again, are deemed a holiday, unless you're that exception for violence, threats, health and safety issues. In unlawful detainer proceedings in 501, all new motions filed in unlawful detainer cases will be assigned new hearing dates after June 22nd. Trials, mandatory settlement conferences in UDs will be continued for at least 90 days on a rolling basis, with the exception of unlawful detainer cases resulting from violence, threats of violence, or health and safety issues. The jury trials for unlawful detainers have also been, jury trials in the unlawful detainers for those cases of violence, threats of violence, or health and safety issues are being continued on a weekly basis based on the availability of jurors. If you practice landlord-tenant law in San Francisco, you are well aware of the San Francisco Rent Board. So we just wanted to touch base quickly on the Rent Board's availability right now. While counter service is closed right now at the rent board, they are taking some documents via mail or email. That includes eviction notices, buyout agreements, declarations, tenant petitions, tenant hardship applications, and duplication requests. They have also started offering phone counseling. And again, I want to make it clear that San Francisco does have a new notice that must go out from the rent board. That is for any notice that goes out served during the state of emergency. In our written materials, we have a copy of that notice, but also it's available from the rent board's website directly.
Okay, we wanted to also let you know that there's a rent freeze that is happening in San Francisco right now. There are other rent freezes across the state. So in Los Angeles, for example, there's currently a rent freeze in the county. In Oakland, there's one that Stephanie will touch on later. So I'll discuss what's going on in San Francisco, as there are some exceptions, but landlords and tenants need to know that right now there's a freeze. So what does that mean? Back on April 24th, Mayor Breed signed emergency legislation passed by the Board of Supervisors, basically temporarily prohibiting certain rent increases on rent-controlled units. So first, the rent freeze applies to all rent increases that are effective between April 7th and June 23rd, unless this gets extended. So even if the rent increase was served before April 7th, it will apply if the rent increase is supposed to take effect between April 7th and June 23rd. So it's a narrow window. It's important to know, though, that rent increases or pass-throughs that went into effect before April 7th are not affected. So, for example, if a landlord served a 60-day notice to raise the rent, let's say back in February, and it was supposed to go into effect on April 1st, well, that rent increase is okay. It's not impacted by this current freeze. The rent freeze only applies to annual allowable rent increases and banked rent increases, and operating and maintenance expense rent increases and pass-throughs for rent-controlled tenancies under the San Francisco rent ordinance. So this can get a little complicated. It's best to talk to an attorney if you have questions about whether you can or can't raise the rent during this time because of this rent freeze. There are some exceptions, like I mentioned, and those exceptions include rent increases for properties that are exempt from San Francisco's local rent control regulations, or rent increases that are allowed by state law, such as rent increases based on the Costa-Hawkins Rental Housing Act or the Tenant Protection Act of 2019, which we know as AB 1482. Also, there's a specific section of the Rent Board, section 1.21. Those are petitions that the Rent Board hears when the tenant is no longer in occupancy. So those are also not covered by this current rent freeze. So if the landlord did serve a notice of rent increase that is in effect during the temporary freeze, the tenant is not required to pay that increase until the landlord serves a new valid notice. And it has to go into effect after the temporary rent freeze expires, which is on June 23rd of this year. So what happens if the tenant paid during the temporary freeze? What should landlords do? Well, they should immediately refund the overpayment to the tenant. Otherwise, if they don't, they could be in violation of this temporary freeze.
So now moving across the bay, we'll talk about the city of Oakland. Oakland has obviously enacted their own eviction moratorium. On March 27th, the Oakland City Council passed an emergency order restricting landlords from evicting residential and commercial tenants during the COVID-19 pandemic through May 31st, 2020. The order makes it an absolute defense to any eviction if the notice was served or if the notice expired, if a complaint was filed or served during the local emergency. The Oakland eviction moratorium applies to all evictions and excludes only those under the Ellis Act or evictions when the tenant poses an imminent threat to the health and safety of other occupants of the property and that threat is clearly stated in the notice as the grounds for eviction. Looking again specifically at non-payment of rent for residential tenants in Oakland, residential tenants can be evicted for missed rent due during the local emergency in Oakland if the rent was unpaid because of a substantial reduction in household income or a substantial increase in expenses resulting from the pandemic. The order indicates a few of these examples, but obviously it's not an exhaustive list. But they give the examples such as when the tenant suffered a loss of employment or a reduction in hours, if the tenant was unable to work because their children were out of school, if the tenant was unable to work because they were sick, or if they were taking care of a household member or a family member who was sick with COVID-19, if the tenant was complying with a recommendation from a government agency to self-quarantine, if they incurred substantial out-of-pocket medical expenses due to COVID-19. The order also requires the landlords to accept rent payments during this time from third parties. So where typically a landlord wouldn't accept rent from a subtenant or someone who's not on the lease during the local emergency, they are required to accept that rent. The City of Oakland's eviction moratorium also generally states that there's no capital improvements during this time. There are no late fees during this period, and noticeably also prohibits rent increases above 3.5% through June 30th, 2020. The City of Oakland also extends protections for commercial tenants, and commercial tenants can't be evicted for non-payment of rent if they are a qualifying business, and the failure to pay rent during the local emergency was a result of a substantial decrease in income that was caused by the COVID-19 pandemic or by any local, state, or federal government response to COVID-19, and that decrease in income is documented. To help understand this a little bit better, a qualifying small business in the order states that a small business is defined by Government Code Section 14837D1A or nonprofit organizations. And then Government Code Section 14837 states a small business is a independently owned and operated company business with its principal office in California, with its officers domiciled in California, with 100 or fewer employees, who over the last 3 years have an average annual gross income of $15 million. The Oakland commercial eviction moratorium, while it has that language about the decrease in income being documented, doesn't offer any further explanation about what sort of documentation. And I also want to note that the City of Oakland's eviction moratoriums for both residential and commercial evictions doesn't include any sort of notice requirement. However, obviously, as a practical point, you want to give as much written notice as possible to your landlord, paper trail that. I will also state that the Oakland eviction moratorium includes precise language that you have to include in any notices that are going out at this time. So if you are planning on serving any notice, please read that ordinance to see the exact language, font, and type that you should include in your notices going forward. Looking at the Alameda Superior Court, obviously, as well, the Alameda Superior Court is closed through May 29th, and March 17th through May 29th have been deemed a court holiday, and no new filings are being accepted. As a result, all civil jury trials have been continued for 60 days, and the deadline for trials to be heard is extended 60 days through May 22nd, 2020. Specifically also in San Francisco, in Alameda Superior Court, the court has stayed all UD proceedings, including evictions, through the extended closure period as well. Alameda has also enacted a bunch of emergency rules of their own. There's Emergency Rule 3.29, which effective April 6, 2020, required mandatory e-service. And then also going on, there's emergency rule 1.8 and 1.8a, which I definitely recommend reading and are included in our written materials, which allow the resumption of, so local rule 1.8 allows the resumption of the court's fax filing service, which was previously suspended due to the COVID-19 crisis, but enumerates emergency-related civil, family, and probate documents that they will be accepting as of April 13th. Emergency Rule 1.8a also expands those types of documents that can be filed at the court's Dropbox locations. And then starting April 20th, the court began hearing limited civil, criminal, and family matters via e-hearing. Some of those are even broadcast live, so you could check those out on the Alameda Court website. Then more recently, on April 29th, the Superior Court further expanded its services by allowing fax filings for motions that had hearings or trials that were originally set between March 17th and May 4th, 2020. So all of those hearings that they will start moving forward with are going to be completely remotely heard. And the court anticipates that it will give you about a week's notice if your hearing will be continued or if you'll be required to appear remotely. They've also started issuing reservations for a limited number of matters that again are identified in the updated Emergency Order 1.8. So taking a step back to Alameda County as a whole, on April 21st, the Alameda County Board of Supervisors amended the existing temporary eviction that was rather limited and instituted a widespread protection for individuals impacted by the global coronavirus pandemic. The supplemental moratorium prohibits now landlords from evicting tenants for any reason except for evictions when the tenant poses an imminent threat or health and safety risk, or Ellis Act evictions through May 31st. But again, as we've seen, this was extended once, it could be extended again. Noticeably worth mentioning from the Alameda County eviction moratorium is that if the tenant can't pay rent due during the moratorium because they suffered a substantial loss of income, which includes due to children being out of school or other childcare needs, or substantial out-of-pocket medical expenses, they must give the landlord notice of the hardship before the rent is due. Then, in Alameda County, the tenant must provide documentation of their substantial hardship within 45 days of the initial notice or within 30 days after the county's shelter-in-place is lifted. Another interesting thing about the Alameda County eviction moratorium is that under the countywide eviction moratorium, tenants have 12 months to repay any back rent that was missed as a result of a COVID-19 related hardship. However, all of the past due rent then becomes a consumer debt that cannot be recovered through the unlawful detainer process, meaning a tenant cannot ever be evicted for a rent they missed for a qualifying COVID-19 reason. The landlord would have to seek it through small claims or other debt collection methods. Further, Alameda landlords are prohibited from imposing late fees, fines, or other interest for unpaid rent. The moratorium in Alameda County applies to all cities within the county and city that the moratorium applies to all cities within the county, and any city that wishes to apply their local moratorium must affirmatively opt out of the county moratorium. So as we just heard, the city of Oakland has one set of moratorium orders, and now they would have to affirmatively opt out of any of the Alameda County ones that were just enacted. I want to raise everyone this issue now since it's somewhat pertinent and coming up in the horizon. The city of Oakland has proposed 60 potential amendments to their eviction and rent ordinances as part of the COVID-19 emergency response. This was initially set to be heard on April 21st with about 3 days business notice of the amendments, but was pushed back and tabled until May 12th, so it's coming up soon. The proposed amendments to the to the tenant protection ordinance and just cause for eviction include limit to the maximum rent increase allowed in any 1 year so that it conforms with state law AB 1482. There's a prohibition of landlords from evicting tenants based on additional occupants if the landlord unreasonably refuses the tenant's written request, even if that comes after receiving notice of a breach of a lease. It includes, it overrides occupancy limits set in the rental agreements. It makes it an affirmative defense to an eviction if the landlord fails to pay the required relocation benefits. It prohibits late fees over 1% of the rent and prohibits unilateral changes in the terms of the tenancy by the landlord. Removes the 15-year exemption on new construction and alters the definition of a tenant, harassment, and privacy rights. So it's something to definitely keep your eye on. Again, that should be heard May 12th unless they push it back again. And then finally, we just also want to make a note that while we discussed San Francisco and Oakland today, there are a ton of nearby counties with eviction moratoriums, including Hayward, Alameda City, the city of Berkeley, San Jose, Marin, San Mateo, Napa County, Sonoma County, Monterey County, Santa Cruz County, Solana County, and Contra Costa. And all of these are changing daily, so make sure you're staying up to date on them.
Okay, we've covered a lot of material, and so we want to now try and package it all together to give you some practical pointers, because there are so many questions about court operations and the eviction moratoriums and what can and can't happen during this time. So these are some humble practical pointers for anyone representing parties that may be impacted by these changes. So first, I'll give some practical tips for landlords or for any practitioners representing landlords. And you have to really think about what can and can't you do because of all these changes. So specifically, if a tenant contacts you, commercial or residential, and says, hey landlord, I can't pay my rent, I'm gonna need a deferment, can you help me out? So what is a landlord to do in that situation? We've been getting a lot of calls from people asking these kinds of questions, and so we're trying to help everyone understand their rights and obligations. So first, you must absolutely know what rules are in place in your city and county. So as Stephanie just mentioned, there's a huge number of cities throughout California that have enacted emergency moratoriums. So you've got to know what's happening in that city and in the county where the property is located. And then if there's no specific city regulation, you'll look to the state one, and then even potentially federally if there's a Section 8 tenant or if the property is backed by a federal mortgage. So you've got to know, really be aware of all three, local, state, and federal. So once you determine whether or not your specific city has an eviction moratorium or certain rules in place, you might consider entering into a rent repayment agreement plan with your tenant. So it's important to understand that if you are going to enter into a repayment agreement, they should really be fair. And many people are arguing, well, you know what, it's too soon to enter into payment plans. We don't know when COVID-19 will get better. We don't know when the government is going to change things. So is it really a little soon? And so landlords, again, just need to be aware of the dates and the rules in their specific county. But whether or not it's too soon, it's really case by case specific. So if you are going to enter into a repayment plan, the agreement should state that the tenant will not be evicted for non-payment as long as the past due amounts are paid according to the schedule in the agreement. And then the tenant also doesn't fall behind on future rent. Really important to know, landlords can't force their tenants to enter into repayment agreements, nor can landlords require tenants to waive any of their rights that they have under the agreement. So it has to comply with all applicable laws. And an example of this is, as Stephanie mentioned, so in San Francisco, you have up to 6 months to repay your back rent. And in Oakland, you have up to 12 months. So a landlord cannot shorten that time. A landlord can't say, well, in San Francisco, you really have 6 months, but you know what, let's make it 3 months. So no, landlords can't do that. they've got to make sure their agreement applies with applicable laws. Otherwise, it would be void for public policy, and they can't really contract for anything shorter. There should also be very specific provisions within repayment agreements, such as how and when the tenant will pay back the rent, the timeline, and those timelines should really be flexible, how much the tenant is paying each month, and then what happens when the tenant misses a payment in the plan. You know, how is the landlord going to enforce the agreement or recover possession of the unit in the event of a breach? There are some forms available through different organizations. So for example, the California Apartment Association, CAA, they have a form. It's pretty straightforward, it's like a page, doesn't have a lot of legalese. Also, the San Francisco Apartment Association, SFAA, they also have a form available for public use as well. You can go to their respective websites and download those forms. Again, with respect to repayment agreements, another tip for landlords is that the agreement should also specify the current condition of the property. So if it's in good condition with no habitability issues, the agreement should state that. So the tenant is basically certifying that the property is in good care, no outstanding habitability problems. But on the flip side, if it's not in good care, there are repairs that need to be made, tenants shouldn't sign anything to the contrary, and landlords should take steps to address any potential habitability defects, as those can be defenses to non-payment of rent actions. So while making any necessary repairs, landlords should also be mindful of the current stay-home orders as well and what type of work they're doing. If the tenant is in compliance with a repayment agreement, landlords can't file an unlawful detainer action against them. And also, UDs can't recover past rent due from more than a year ago. So that's one reason why rent payments should be applied to the earliest past due rent amounts. The agreements cannot or should not list any past due charges other than rent. So examples of that would be late fees or interest or other types of charges that aren't rent. Non-rent amounts can be claimed in other ways, like breach of contract or breach of lease actions, once those are permitted. And also, we've gotten a lot of information that various groups or tenants unions are advising tenants not to sign any repayment agreements and telling tenants just don't sign them. So tenants aren't required to sign them. And if landlords want to consider having a repayment agreement, they should make them succinct. They should make them user-friendly, remove unnecessary legalese. Again, like I mentioned, CAA and SFAA have forms available for public use for this. I wanted to touch on a couple of San Francisco specifics, so things to be aware of in San Francisco. Because the eviction moratorium was extended into the end of August, potentially evictions for owner move-in, so what we may know as OMI evictions, if there are minor children or educators in the tenant household, they can't be evicted during the school year. So what that means is typically during non-COVID times, if you are going to serve an OMI or owner move-in notice on a household that has a minor child or an educator, you have to serve those notices prior to June 18th. Otherwise, you'll miss the school year cutoff. Since the San Francisco school year is supposed to begin on August 17th, OMI notices have to expire before that date. Otherwise, the eviction has to wait a whole nother year until 2021. So now, because the moratorium was extended until the end of August, basically these types of OMI evictions are going to have to wait until 2021 for qualified households. But again, in San Francisco, evictions due to violence, threats of violence, or health and safety issues, or the Ellis Act, those can go forward. A lot of people have called and asked us, well, what does, a violence or a threat of violence or health and safety eviction mean? And that's going to be determined on a case-by-case basis via probably an ex parte application with Department 501 in the San Francisco Superior Court, showing why that eviction should go forward if it fits one of those exceptions. But take into consideration the court of popular opinion. So how will a judge or a jury view your client's efforts to regain possession in the middle of a pandemic? I also wanted to mention the anti-price gouging statute, which is triggered by Penal Code Section 396. So what that means is when there is a declared state of emergency, like we are in now, you cannot raise the rent by more than 10% during that declared state of emergency. So really important to know that any efforts to raise the rent by more than 10% right now would violate Penal Code Section 396. There are some other a little more nuanced layers to Penal Code 396. So if you are thinking about serving an increased notice, definitely understand San Francisco, there's the rent freeze for certain properties, but also there's the statewide Penal Code Section 396 anti-price gouging statute that you have to be aware of too. So talk to an attorney if you're thinking about raising the rent, but better advice is just hold off for right now. Probably not happening. And so Stephanie will give us some tips when representing tenants.
Yeah, so basically the reverse of everything Anna just went over. So if you represent tenants and you have an individual who comes and they can't pay their rent, first and foremost, understand the reporting and documentation procedure for the local city and county, the time frame for providing notice, what documentation they need, if they can even qualify under the local definition of financial impacts related to COVID-19, to understand what their options are completely. Anna talked about there's a lot of push right now from landlords to be entering into these rent repayment agreements. And as a tenant advocate or a tenant attorney, you want to understand that this is, make sure your clients understand that this is not a rent waiver and the tenant will have to pay back any missed rent. So if they really can't pay it back, you need to structure these rent repayment agreements in a feasible, financially manageable way for your clients. You need to understand first the amount of time the tenant has to pay back under the local ordinance. Is it 12 months? Is it 6 months? Is it 1 month? Then you have to talk with their client and understand what they can pay on top of their monthly rent going forward once the moratoriums end. So a tip I think is important right now is assigning rent payments as tenants are paying them each month. What that means is actually writing out on your rent check what month that rent check is for. To give a practical explanation of how this would play out. For example, San Mateo County, their rent eviction moratorium ends May 31st, 2020. That means June 1st, all of these tenants are going to be required to pay their rent in full with no moratorium protections. So a tenant then gives their landlord June 1st rent, and the landlord could apply it to any missed back rent for April or May. Then the landlord could serve a 3-day notice for the June rent, and the tenant would have to pay the June rent again, in essence, with no protection under the local the local eviction moratorium. So if the tenant then writes June for June rent payment, they'll be protected and the landlord will have to apply it then for June, and they can use those eviction moratorium protections for any back owed rent. Another practical consideration for these rent repayment agreements is to ensure that they don't waive any of the tenant rights, either under the local moratoriums or basic local ordinances, right? So you want to preserve all of your affirmative duty defenses. If there are habitability issues, make sure you're raising them. Don't sign any agreement that says the apartment is in perfect condition if it's not. Don't agree to pay back in 6 months if the ordinance gives you a year to pay it back. Also a point, you want to make sure that the agreement doesn't give the landlord an immediate right of possession if the tenant violates the repayment plan. And I mean this as in either if the tenant, in San Francisco, for example, the tenants have 6 months before the landlord can attempt to recapture possession of the unit. And let's say the tenant has a 6-month payment plan with the landlord, but they miss payment 3. You don't want an agreement that says the landlord then can immediately regain possession if they miss a single repayment plan, if otherwise under the moratorium, they would have had those full 6 months. Also, you don't want anything in the agreement that's going to let the landlord sidestep any other practical or procedural unlawful detainer proceedings they would otherwise go forward. You don't want one violation of your repayment agreement and the landlord can go in ex parte for possession. Beyond repayment agreements, expect a rise from a tenant attorney perspective in tenant harassment or retaliation if a tenant's not paying rent and they have all of these protections. To be clear, to start, there's no self-help in California under California Civil Code 789.3. So under no circumstances is a landlord allowed to attempt to make the living conditions uninhabitable in order to get the tenant to leave. They can't change the locks. They can't cut off services, housing services, utilities, or physically move the tenant's belongings out of the property. The only authority that has the ability to lock out tenants is the sheriff's office after they've received a directive from the court. And landlords who use self-help may have their case thrown out if they go with a UD afterwards, or they can just be sued for damages by the tenant. I expect that there have been privacy issues that are coming up for tenants, especially tenants who have tested positive for COVID-19. Tenants have a constitutional right to privacy, including medical information such as their status regarding COVID-19. Landlords don't have any duty to inform other tenants regarding COVID-19 or a tenant's status with COVID-19, and doing so even generally may open the landlord up to liability. And finally is harassment and retaliation. I'm sure we've all seen in the news about landlords harassing tenants about payments. I saw one news story where a landlord was caught on camera climbing through the window trying to force a tenant to move out when they became positive with COVID-19. If you are representing a tenant who is experiencing this, obviously, you want to document all of this. You want to gather your evidence now so that you can build up your case when it comes time to finally file a new complaint. Gather your video recordings, get your pictures, keep those documents, and build your paper trail now. I also lastly want to touch on insurance issues. As a tenant attorney, you understand the concept that you're going to be filing this complaint against the landlord, and the landlord will tender it to their insurance policy. However, this has obviously been a drain on all resources, not just landlord and tenants. And we have heard reports about carriers not making settlement offers, refusing to fund settlements, staggering settlement payments. So be creative with your settlement agreements if it comes down to that. Be prepared for maybe not to be as quick as you have initially experienced in the past with your settlements. And then I also want to touch on a point with mediations right now. Let's say your carrier wants to go to a mediation and the mediator is offering a Zoom or an e-mediation. You want to evaluate whether or not your case is right for a distant or remote mediation. How much are you going to need the mediator to put pressure on the carrier or the landlord for those payments? Are you going to need a contribution from the landlord themselves that's going to require some arm twisting? Is this a good case to do that over the phone, or do you need to be in the same room? All food for thought. So Anna and I have gone over a bunch of things that you can't do right now. And so we wanted to touch base on some theoretical considerations, creative ways for you in your practice to move your matters forward right now.
Exactly. So we've been getting a lot of calls and emails from clients and friends and other people saying, okay, you told me everything I can't do, so what are our options? What can I do? So there are alternative types of proceedings to address a lot of the issues that we've touched on today. In the interest of time, we won't spend too much time getting into detail on them, but you should be aware that you can potentially move these types of cases forward despite the current moratoriums. So we'll give you some alternative options. So as to claims by landlords, although there's some indications that shelter in place will end or at least ease, before too much longer, the existing state and local restrictions on unlawful detainers are going to be in place for a while. So there are other alternative remedies to address any potential misconduct by residential or commercial tenants. So one option is ejectment. What is it? So it's an alternative type of eviction proceeding, which can be filed against either residential or commercial tenants if the tenancy has been validly terminated by proper written notice. Ejectment actions don't go through court as quickly as unlawful detainers, but again, unlawful detainers aren't really going through court very quickly right now either. But ejectment actions will take longer despite the current moratoriums. But the filing of the lawsuit and the use of any potential pretrial discovery can suffice to bring the tenant to the bargaining table fairly quickly, especially if the tenant has no viable defenses to the lawsuit and they don't want to be exposed to mounting claims for damages or for attorney's fees if the lease provides it. Also, because of Proposition F that passed a couple of ballot measures ago, Proposition F gives any tenant in San Francisco the right to a free lawyer if they're being faced with an eviction. And that's regardless of means or anything else. Just all tenants facing evictions get a free attorney. But if a tenant is facing an ejectment action, which is not technically an unlawful detainer, they wouldn't be able to avail themselves of that right to a free lawyer. So some clients have opted to go that route to avoid the free attorney triggering by Prop F. Another potential alternative method that's available is nuisance or waste actions, and those are general civil lawsuits. But that only applies if the tenant's misconduct consists of something like nuisance or waste or harassment. And you can potentially seek a restraining order or an injunction for behavior like that. Additionally, for commercial non-payment of rent evictions, landlords may also be able to seek a pretrial writ of attachment, which would serve to freeze cash or other assets, and it could put financial pressure on tenants to settle. It also potentially increases the odds that assets would be available to execute upon if the landlord actually can obtain a judgment against a tenant. So those are other options for commercial real estate issues.
Another hot topic and question we've been getting a lot about recently is the viability of force majeure clauses in contracts, either to get out of a lease or to get out of a rent payment. Generally, force majeure clauses are contractual provisions which excuse one or both parties' performance when circumstances arise which are beyond the parties' control and make performance of the contract impossible. We go into some case law detail in the outline, but determining whether a force majeure clause can be invoked is a very fact-specific and looks at the language of the contract and the clause, and they're usually very narrowly tailored to the substance of the contract. Typically, they apply to contracts for services and goods and not payment of money such as rent. We generally would recommend that you will have more success if you are looking for relief under a federal, state, or local eviction moratorium than trying to invoke the force majeure clause. That being said, all's fair game in a general global pandemic. So some intellectual food for thought. With all of these local orders and moratoriums coming up, we wanted to draw your attention to two cases. The first one, Birkenfield v. City of Berkeley and Channing Properties v. City of Berkeley. Birkenfield v. City of Berkeley is the first case that discussed or reviewed the validity of local rent control measures and the limit on municipalities when they conflict with state law. So if you want to look into those, if you haven't yet, those are two good cases that explore that concept. So now, what happens when the moratoriums end and what's the reality of practicing going to look like? The courts are going to be backlogged. I don't think it's a secret that Alameda County Superior Court was backlogged to begin with before even the global pandemic hit. So expect a lot of continuances. Alameda is pushing very hard right now. I know San Francisco is as well to get e-hearings, remote hearings up and running. But there's also going to be a widespread economic impact of this. The moratoriums end, rent will still be owed, unemployment will still be exceptionally high. And I think the overall feel right now is that we should be working towards agreements between landlords and tenants rather than trying to push people along this road when it's already going to be so backlogged.
We're also watching some proposed legislation pretty closely, so keep an eye on it. A couple of bills that we just wanted to briefly touch on and make you aware of. The first is AB 828. It's Assemblyman Phil Ting's proposed legislation. You may have seen various groups protesting this, or I think I saw some groups writing letters trying to have this not go through. So basically AB 828 gives the courts power to further delay non-payment of rent evictions. And potentially, this is the big one here, if a court finds that a tenant was unable to pay their rent because of COVID-19, the court would have the power under this proposed legislation to reduce the rent for the property by 25% for the next 12 months. So as you can imagine, a lot of landlords are not happy about hearing about this. Small landlords would have an opportunity to demonstrate their own financial hardship resulting from reduced rent, but many landlords just don't like the fact that the court could intervene and say, hey, your tenant's rent is now reduced by 25% for a full 12 months. So that is one to keep an eye on. That would be statewide in California. A local piece of legislation to also watch is Supervisor Dean Preston. His proposed legislation will be heard this month in May, and it basically, in a nutshell, would prohibit a landlord from ever evicting a tenant for non-payment of rent for a certain period of time for that portion of rent if it was COVID-19 related, meaning their inability to pay. So it doesn't mean that the rent is waived. It just means that a landlord can't evict a tenant for it. So a landlord would have to sue the tenant in small claims court or bring a general civil action for that money, but they couldn't use it as a means to start an eviction action. I also recently saw a bill down in Long Beach, basically saying that the state would cover 80% of rent forgiveness if the landlord would forgive the other 20%. So that's what's going on down in Long Beach. There's tons of proposed legislation throughout the state, but these are just some of the ones that caught our eye that we're also closely watching, especially the local one here in the Bay Area.
So just some parting thoughts before we leave. First, the information in this program is based on the rules in place as of today, May 7th, 2020, and is not exhaustive. There are new orders at the local, state, and federal level almost daily. We can't stress the importance of staying up to date on these issues if you are practicing landlord-tenant law. And it's also important to remember that these are uncharted territories, and landlords, tenants, and practitioners need to be collaborative and creative to ensure we all get through this together. Thank you. Anna?
So thank you for joining us. We hope this was helpful and informative. I did see one question come in. I'll go ahead and read the question, which is the San Francisco Housing Court still conducting hearings on ex parte applications with personal appearances by attorneys as opposed to telephone appearances? And the answer is no. Those ex parte hearings are being done via court call, so they're being done by by phone. If there are any other questions, feel free to throw them on the chat. Otherwise, our email addresses are on the PowerPoint. Our phone number is there. If you have any questions, shoot Stephanie and I an email. We'd be happy to chat. And thank you again for joining us today.